It's a great pleasure to introduce Elaine Harwood to you. Many of you know Elaine. Many of you have worked with Elaine. Elaine is the head of the accounting practice at Cornerstone Research, and many of us have worked with her as people who have, well, she's really supported us as experts, or she and her team. Through her own work and through working with so many academics, she's had a great deal of exposure to very complex cases, many of which have involved fraud. So there's no one better to set up this panel, and Elaine has put an incredible amount of effort into doing this. So without any further ado, Elaine.
Thank you, Peter, for that kind introduction. I do notice, though, that you forgot to mention what you started the morning with, a discussion that we all learned earlier this morning, that I am one of the two people that Peter recognizes when he has a nightmare. Now, despite that fact, I am delighted to be here with this distinguished panel to talk about fraudulent financial reporting and litigation and regulatory action. So our panel consists of Russell Duncan, who is a partner at Shulman, Rogers, Gandel, Porty, and Ecker, and he is the chair of the firm's government investigations practice. Russell is the only attorney in private practice to have served as a senior trial attorney for the DOJ, the SEC, and the PCAOB. And in those roles, he has worked on over 500 matters. In addition, for 15 years in private practice, Russell has been involved in hundreds of matters, including those involving allegations of accounting and financial fraud. Cindy Fornelli is the executive director of the Center for Audit Quality. In that role, she is responsible for carrying out the mission and vision of the CAQ's governing board, which is comprised of 8 leaders from public company audit firms, the AICPA, and 3 independent members. This year, Cindy was named the NACD director to the NACD directorship list of the 100 most influential people in corporate governance for the 8th time. She has been included in Accounting Today's roster of the 100 most influential people for 9 consecutive years. And Cindy is a former securities lawyer. Zoe-Vonna Palmrose is the Hanson Professor in Business Administration in the Foster School of Business at the University of Washington at Seattle. She has published, taught, and spoken extensively on issues related to the quality of financial reporting and auditing, including fraudulent financial reporting. Zoe-Vonna currently serves on the Center for Audit Quality Research Advisory Board and the Deloitte Audit Quality Council. She previously served as Deputy Chief Accountant for Professional Practice in the Office of Chief Accountant at the SEC, a member of the PCAOB's Panel on Audit Effectiveness, and as a member of the Auditing Standards Board Fraud Task Force that developed SAS 99, Consideration of Fraud in a Financial Statement Audit. Thank you all for being here with us today. Yes, it worked. We've structured our discussion today to cover 5 topics. First, the panel will provide an overview that'll give you a sense of how to navigate the litigation and regulatory enforcement landscape in connection with both your teaching and in research. Next, we'll cover some of the proxies for fraudulent financial reporting, many of which have been discussed today, but also address the challenges that arise in using those proxies. We'll then turn to exploring the frequency of fraudulent financial reporting, and we'll discuss some of the common fraud schemes we've seen over the years. We'll wrap up with issues to consider in connection with research. So that we can have an interactive discussion, we do welcome you to ask questions of the panel members as they are discussing some of these questions. So first, Zoe-Vonna, could you start us off by defining what we mean by fraud for the purposes of this panel?
Sure. Thank you very much, Elaine. It's clear from the very interesting and often entertaining discussion so far today that fraud is a very broad topic. But for the purposes of our panel, we're going to primarily focus on fraudulent financial reporting. As shown in the first bullet here on the slide, this means that our discussion will largely involve material misrepresentations from an intentional failure to report financial information in accordance with GAAP. And this definition was developed by the CAQ as part of their fraud initiative. It's consistent with the definition in the auditing literature, PCAOB auditing standards, as shown on the slide. But it also means that our discussion is not going to cover topics like insider trading, occupational fraud, other illegal acts and forms of misconduct, such as under the Foreign Corrupt Practices Act and the like. But I think Russell wants to provide a little bit of color on our definition here from a legal perspective.
And thank you very much, and thank you, Elaine, and Peter, thank you for inviting me. As I was looking at three definitions that we put up here on fraud, the thing that struck me, it's two words have to jump out at you each time. One is it has to be intentional, and two, it has to be material. Intentional is very simple. You can't do it by accident, you can't do it by mistake, you can't do it by inadvertence, and you can't even do it by negligence. So when you find someone who's involved with fraud, you know one thing's for sure, they know exactly what they're doing. The other thing that has always struck me about this is you have to have a material misstatement. And again, I think that's a term that's probably familiar to you all, but it's not familiar to the ordinary public. So someone will say, well, that thing is false. And I said, yeah, but it doesn't matter unless it's material. It's got to actually affect an individual's decision on whether or not they would make an investment or whether or not they would do something with respect to a security. The third thing that isn't as prominently featured, but is also very important, is it has to actually be false. I have clients all the time who will tell me, well, Russell, this is a judgment call. Is it okay for me to do it? And I said, sure, it's okay for you to do it if you think that an objectively reasonable person is going to agree with you. If you can tell your rabbi or your priest or your friendly enforcement regulator with a straight face what you've done, then you can go ahead and do it. But if you can't, give me a call. So those are the three things that are very important. And the last thing and it's just a quote that I've always loved because it really does speak to how wide-ranging and intricate and just fascinating fraud can be, is a quote by one of the judges from the Second Circuit who's quoted there at the bottom, that fraud is just really limited by human imagination. And you can't even imagine all of the things, but my favorite was always the 25-year-old kid who created a company in his parents' basement using Microsoft Word and then sold it to a large government contractor in Washington for $3 million. So the ability to create financial false statements is not limited just to the sophisticated, but it's also to the industrious. So you find fraud in every way, shape, or form. And the thing that has always struck me about it and continues to show, even though I've been doing this for almost 34 years, my naivete, is what people are willing to try to sell to other people as true. And that's where you get into some of the real interesting issues in fraud.
Thank you, Zoe-Vonna and Russell. So Cindy, the CAQ has presented a framework of the roles and participants in the financial reporting supply chain in mitigating the risk of fraud. And this was something that you put in your October 2010 publication, Deterring and Detecting Financial Reporting Fraud, a Platform for Action. Could you please give us an overview of that framework?
Certainly, and it's good to see everybody here. One thing I will tell you, if it's hard for you to read that slide, we do have it available in the CARE conference website, and it's also, of course, in the report that Elaine just mentioned. But as we set out at the CAQ, looking at the role that the external auditor played in deterring and detecting financial reporting fraud, it became very clear to us that the external auditor isn't the only player in the system that has responsibility for deterring and detecting fraud. In fact, I would argue that company management has the primary responsibility for deterring and detecting fraud. So we wanted to find a way to capture that. And so we came up with this little chart here, and you'll see that management's down at the bottom and they're at the base of the pyramid because, again, we posit that they have the primary responsibility for the preparation of the financial statements and making sure that they don't have these material and intentional misrepresentations in the financial statement. So that's why they're on the foundation. And then we move up to the internal auditor and the external auditor, whose role it is also to check the work of management, if you will. And then finally, we have the audit committee and the board of directors up at the top. So that's how we visualized it, and we were very pleased when we reached out to these other groups that represent these other parties, that they all agreed that this indeed was a good, accurate visual representation of the roles and responsibilities. And then one other thing I would say about management, and we heard a little bit of that at the last panel, was the importance of tone at the top and the corporate culture. And of course, that is management's responsibility to set that tone. So that's kind of how we came up with this. This we thought was a good way to kind of visualize and remind all of us that all the players have a responsibility and kind of what those roles and responsibilities are.
And not surprisingly, given that responsibility, each of the parties in the financial reporting supply chain can face litigation and regulatory action. Russell, could you provide an overview of what that landscape looks like?
Certainly. There are really only three major players in the litigation landscape. I'll go through them in order and then tell you a little bit more about some of the more minor players. But the SEC is by far the most active in this area. I worked there for several years in the trial unit and saw just an incredible number of cases. And since that time, 10 years since I've been there, both the quality of the work and the scope of the work has increased substantially, and a lot of the reasons you've heard already today, some of the very fine tools that they have come up with in order to uncover financial fraud. The second player, and not nearly as significant, is the Department of Justice. But the Department of Justice is clearly the most scary. I tell people all the time, the worst thing in the world to have happen to you is to have an FBI agent interested in your business. And the second worst thing is to have an FBI agent who has the ear of an assistant U.S. attorney, because you could go to jail. And that's the thing that drives. Every client I have who has both parallel SEC and criminal proceedings, we spend 99% of our time working on the criminal side, and maybe the SEC comes later. The third major player you see is the private shareholder litigation, and that's largely driven by the plaintiff's class action bar. Their actual role is less significant, I would say, largely because they are generally follow-on. They either find their cases from SEC enforcement actions that are announced or from restatements that are done by companies. And frequently, though they help make a lot of lawyers wealthy, they don't really have much impact on keeping down financial fraud. We also, you see a little bit more, and again, it sort of depends, it varies from state to state. State regulators have become a little bit more active, and I've seen this both in my own jurisdiction in Maryland, where I practice, where the Securities Commissioner has become more active, and also in New York, not surprisingly, because of its focus on Wall Street and the fact that I think actually the last two attorney generals have become governor, Spitzer and Cuomo, and Mr. Schneiderman, I think, is working to become the third. So you get to see, so sometimes, as in a lot of these things, politics drive the investigations.
Isn't that what AG stands for, almost governor?
Very well could be. I remember when I was at the SEC, the director of enforcement and Elliot Spitzer had a very interesting relationship. You at least used to hear them talking over the phone in loud voices. Mr. Spitzer had a way of making big, flashy press releases and then saying, "Oh, hey, SEC, you ought to investigate this." So it's a tool that can be used. The third, or the other major agency that I worked for, was the Public Company Accounting Oversight Board. Its role in financial fraud investigations and financial fraud misstatements is much less limited, because they're limited solely to cases involving auditing firms. And largely, those, again, tend to be follow-on or related investigations to the SEC. If they're significant, generally I found the SEC has already taken care of them. And the PCAOB, I think, started as a very good idea. I'm not sure how effective it is as a regulatory tool. And the last thing, obviously, I've actually have a case right now with the Maryland State Board of Accountancy. It's a very important organization because those are the people who can pull your license. It's equivalent for me if the bar were after me. So they can have some impact. But those are the 6 major players you see in the regulatory field.
Elaine, can I make a couple of comments? First of all, I know some of you are interested, or maybe everybody is interested in research here, and we're talking about the intersection here of fraudulent financial reporting, litigation, and regulatory actions. And I'd just like to make the point that from an empirical standpoint in particular, it's really important to think about this holistically. Data gathering may be a bit of a challenge here, because for many research questions, you need to really have data on all the legal actions and all the regulatory actions that are going on out of one circumstance. For example, I do work with auditor litigation, and I try to collect data on not just the class action, but the plaintiffs who opt out of the class, to follow through what resolutions are with those to the extent that I can, follow through on all the regulatory actions by the SEC, DOJ if there are, PCAOB, and Attorney General if there are. So it is a complicated landscape in some sense for data gathering, but if you want to answer some important research questions, I think you really have to address them holistically. And then the second point, I'd just like to disagree slightly, not disagree, we're not going to disagree, we're just going to provide a different perspective here in terms of class action litigation. It's really important not to underplay the role here of class action litigation. Remember, there's really sort of 2 objectives here from litigation and regulatory actions. It's deterrence and compensation. And we can ask, how effective our legal system is at deterrence, and compensation, how effective our regulatory system is at deterrence and compensation. So those kinds of many questions sort of flow from that. But you do want to think about how this class action system works. You want to think about the role of D&O insurance. You want to think about how that pushes, first of all, who gets sued. So that's a pot of gold. It pushes settlement. Very few go to trial. And if you're tried to verdict, my understanding is that these D&O policies have fraud exclusions in them, so that's not going to cover the defendant that is found to be liable under verdict. Plaintiffs' attorneys don't want that because they don't want to lose that pot of gold, essentially, to get a third or so of their fees. And certainly the defendants don't want to lose it either in terms of having the coverage. So don't neglect the role of securities class actions here in this setting.
And of course, it just really adds a lot of complexity when you have multiple actions. I'm sure, as Russell can speak to, and we may get into more detail later, when you have an SEC action at the same time as a shareholder action, at the same time as something else going on.
We consider that a great business plan.
So one thing is pretty clear from the discussion that's led up to our panel is there's been a lot of discussion of fraud firms, and embedded in that discussion is that there's been a proxy that's been applied to define a fraud firm, because rarely do we see someone coming out and saying, yes, I did it, and that being very publicly available. So I think, with this keen interest in how we can identify and measure fraudulent financial reporting, we wanted to start out by having Zoe-Vonna take the lead and Russell and Cindy chime in on some of the proxies that are being used and some of the challenges that we face with them.
Sure. So first of all, let me start off. There's a number of proxies, potential proxies listed here, but let me comment on some of the issues from a research perspective. I think it's really important for researchers to be very clear about how they're measuring fraud and how they're using the term. Remember, we're using the term here as fraudulent financial reporting requires intent. It's not necessarily the way that we've been using that term today in terms of earnings management, even manipulation, that sort of thing. So I think researchers need to be very clear about what they mean here by the term they're using, fraud, and how they're measuring it. And there's going to be no perfect measure. There's going to be limitations with all of them. But that said, I would really encourage you to think about using objective measures that involve not allegations, but independent determinations that fraudulent financial reporting has occurred. For example, it could be a board or audit committee investigation that concluded fraudulent financial reporting had occurred. It could be criminal convictions or guilty pleas that were admissions, essentially, of or determinations by the court that fraudulent financial reporting had occurred. It could be SEC enforcement actions. We've talked a lot about SEC enforcement actions, and it's really important component of the agency and for our markets. But we as researchers probably invested a whole lot in enforcement actions because that's where the data have been available, essentially, to analyze. And I think we need to think closely about the usefulness and limitations of AAERs, for example, in doing fraud research. For example, it might be important to think about, first of all, these are settled, or whether they're with or without admissions, it's not an investigation. But it could be important to see the nature of the claim. For example, books and records. So there's an AAER over books and records. Now, I realize some would argue, well, that just means that the defendant had a good attorney and got it negotiated down to books and records. But others would argue, no, that's a really sort of weak claim on the part of the SEC and probably not so meritorious, and the defendant settled in order to just get it behind them. So, you see, it's not always going to be obvious, and at least you want to think through what these, you want to understand and think through what it might mean for your research question.
So can I interrupt here and just give a little bit of a deeper dive on some of the difficulties, I think, of doing research based on the SEC AAERs? We at the CAQ commissioned a study recently where we had a law firm go out and look at SEC enforcement actions that were focused or that had an internal control over financial reporting aspect to it. So they looked at over 200 cases, enforcement actions over a 2-year period, and they were able to cull down from that 42 cases that had an ICFR component to it. And just the number of man hours it took them to cull through that, to get that information, to come down to the 42 cases was incredible. I was very naive about the amount of work that it took for them to go through and do that, because not only then did they have to go through and look at the enforcement cases, that was their start, but then they went and looked at the company's websites, looked at their SEC filings. So it really took a lot of time and effort for them to do that, and we were only focused on categorizing the underlying issues. So if you wanted to do even a deeper dive, it would have taken many, many more man hours to do that. So I tell you that not to give you ideas of how to do research better, but just to kind of give you a backdrop of how difficult it is to do that type of research. And then, I do think that there could be some biases in the SEC cases, in the sense that, I don't mean this at all pejoratively, I worked at the SEC, so I have immense respect for the agency and for the enforcement division, but they have limited resources too, and so they're going to look at cases where they think they're going to have a high rate of success to be able to successfully bring a case. And so that might skew things too as you're going out and looking at that. So they're going to do maybe more high-profile cases, maybe cases that have a CEO or a CFO as one of the defendants. I know there's statistics out there from, I think, the Ethics Resource Center that 89% of SEC fraud cases have named the CEO or the CFO. I don't know if that's because of the high number of incidents that those people, because they have the power to be able to do cases in nefarious or do nefarious types of activities, but also, if you're an SEC investigator and an enforcement attorney, you're going to want to go after the biggest fish that you can because it's a good example for people. So these are all, I think, finer points on the point that you were making, Zoe-Vonna, that using the AAERs and the enforcement actions is difficult to do research.
Yeah, and let me just add a little bit more color to that in case it might be useful. Again, I worked at the agency, and like Cindy, I have great respect for the agency and its work. But you have to remember that what you're seeing here is language crafted by the SEC, not by the defendant. In other words, that really doesn't get to be, you can speak to this, Russell, there's not much negotiation room over this from what I understand. So I always thought, Craig Lewis got to have his wish list. So on my wish list would be Wells submissions. Have you heard of Wells submissions before? So if those were publicly available, you would get a much better flavor of the case and the strengths and weaknesses of the case, because it's really essentially the defendants giving their best shot at why they shouldn't be have an action against them. But again, that's private information that's not publicly available. And there are probably good public policy reasons for that. But you do have to remember that you are not getting necessarily an unbiased essential reading here.
Yeah, it's certainly nothing you can say is subjective, and maybe to Zoe-Vonna's point, actually a lot of the negotiation for what goes into a settlement happens beforehand, so the language is sort of predetermined. The language itself, generally in my experience, the SEC is not willing to give much on that, but you've actually done that negotiation beforehand. So don't think, and I think this is the point you were making, Zoe-Vonna, I think you're right, is that it's not necessarily a reflection of reality, it's a reflection of what the people have decided to settle for.
I will say, though, and I'm looking at David and others from the SEC, that I think recently there has been a trend where commissioners are less sanguine about letting there be, without an admission of, without admitting or denying guilt. And so I think maybe in more recent cases you might get a better flavor, because I think maybe the language isn't as highly negotiated. But David's shaking your head now.
Well, there's just very few admission cases, but you're right, there would be no wiggle room there.
Yeah, there'd be more a wealth of better information. So if you wanted to do research, look at the admission cases. Maybe, I don't know.
There are very, very, very few accounting-related admissions cases, but your point is right. That's right.
If I may, just on that point, I came from a federal prosecutor's background where 9 years where you either did it or you didn't do it. And when I went to the SEC, I was sort of surprised by this neither admit nor deny. And if you look at something, I think David mentioned the Computer Science Corporation's case, which is something I actually had some involvement in, so I can't say a whole lot about. But the conduct was egregious. It lasted over a period of years. It went through multiple countries. It clearly came from the top. There's a wonderful quote that the SEC quoted the CFO saying something like, when he had literally just made up numbers, and he told the investing public, well, we do it the old-fashioned hard way. That's how we get our earnings. And I said, yeah, the old-fashioned hard way. You make it up. That's not that difficult. But that was the case that cried out for admission, and even within that frame, the SEC has sort of I guess it's a historical reason, and there are some policy reasons for it as well. I do know that with Chairwoman White coming from a prosecutorial background, I think there's been a little bit more focus on people admitting what they do. And again, I've just always found it just somehow seems improper that you could commit this massive fraud and agree to settle it, pay a fine that is less than what you stole, and then say, I didn't necessarily do it.
And Russell, going back to the players in the landscape, it was not just the SEC, but the PCAOB as well, which you have experience with, I think, now on both sides. Is it the case that what is being said about the SEC and the settlements and the negotiation of them, does that apply as well to PCAOB actions?
Well, PCAOB actions, it's another world of Alice in Wonderland, because in the PCAOB world, nothing is public until it's public. In the SEC, the mere filing of charges, even the receipt of a subpoena by a company could cause the company, could force the company to actually make do a press release, file an 8K, and admit it. In the PCAOB world, unless the case is actually settled and there is a finding or a decision that something wrong was done, you're not going to know about it. And I know about a lot of these cases that you don't know about. And it would really astound you at the cases that don't get brought, and especially against a lot of the big four accounting firms who have, I would say, very fine lawyers. And there's a reluctance by any agency to take on a situation where they think they're going to lose.
Let me just jump in here. I actually had some more on the proxies, which we'll come back to, because this discussion, I think, is really important. So this is a potential question. As many of you know, or what Russell's talking about here is that SOX precludes having any disclosure of enforcement until it's gone through the process, including any appeals to the SEC. So that's actually in SOX, and it was, Congress spoke, and it was intended to be that way. And one argument potentially for that is that this is a new agency. They're just starting off. It's unclear what kinds of cases they're going to bring, where they're going to draw, put the line here, how they're going to work with the SEC. So some might argue that it's important to go through a learning process. Now, the PCAOB doesn't agree with that, and they've been trying to lobby, I guess I can't, maybe that's not the right term, but anyway, they've been trying to get Congress to consider changing SOX in this regard. But it's an important question, and one that would be deserving of attention. I don't think there's an answer either way. There's usefulness and limitations of both that we should clearly understand.
I certainly have an opinion on that for what it's worth, and it's just my opinion. I think that the accounting firms had better lobbyists than the PCAOB, and they were able to get into the bill what they wanted to do. And again, I'm speaking again from a perspective of a puritanical New Englander prosecutor, that there's no good reason, if you have an enforcement program in which you're trying to inform the public and have a measure of deterrence, to keep proceedings secret.
So I'll push back a little bit on Russell on that, and before you accuse me of being self-interested, I was at the SEC at the time that Sarbanes-Oxley was was enacted by Congress, and I was, as Elaine mentioned, I'm a recovering securities lawyer, so I was in the Division of Investment Management at the time and knew nothing about auditing and accounting, and it predated the Center for Audit Quality. And I don't think that was something that the firms were trying to get into the legislation. I don't really think that they were that organized, frankly, around some of the provisions of Sarbanes-Oxley. I do think if you go back and look at some of the legislative history, to the extent that there is any there, I think, Zoe-Vonna, you're right, more right in that it was because it's a new nascent organization that was trying to be stood up, kind of a new organization that they hadn't really had something like that before. And then I think part of the thought, too, was that because of the SEC's oversight of the PCAOB, in particularly egregious cases, the SEC would take on the investigation, and then, of course, it would become public, so that there was an escape valve, if you will, for the public, in that if there was an egregious case by one of the firms or one of the accountants, it could be made public through an SEC investigation.
And again, from a public policy standpoint, there's some other interesting questions about what type of agent or organization, because it's not really an agency, the PCAOB would be, and for many years it talked about itself as a prudential regulator that was not primarily focused on enforcement, but focused on inspections and standard setting. So again, all of these enter into considering it, but these are important questions that we should be part of the dialogue on if we want to have evidence-based decision-making.
Yeah, and Zoe-Vonna mentioned, and I see we have a question up there. Zoe-Vonna mentioned that the PCAOB has been appealing to Congress to maybe reconsider that provision and some other provisions in Sarbanes-Oxley, and so I don't think that the final answer has yet necessarily emerged.
Is there a question? Yes.
One question, and this comes up to something Russell was talking about. I never quite understood. What's the threshold when the DOJ should?
So the question for those who are having a hard time hearing it was, what's the threshold when the DOJ takes action?
Yeah, when you talk about, Russell, you talk about, there's the SEC and the DOJ, and the DOJ is involved 99% of your effort. that, how should I think about when the DOJ is going to show up?
Headlines and money. It's got to be a big case, it's got to be prominent, it's got to get people's attention. Again, take a look at the Computer Science Corporation case. I don't, again, I have no firsthand knowledge about whether that case cries out for criminal prosecution, as a lot of the cases the SEC does. I mean, almost every case the SEC does could have a criminal component to it, and very few of them do.
But I think that the SEC, I won't put any pressure on current SEC officials, but I think the SEC, Division of Enforcement, and the Department of Justice have frequent conversations, and there is a lot of discussion about, when does it make sense for just the SEC to take the case? Sometimes you'll see the SEC and Justice take a case and do it jointly, and then sometimes Justice will take it. So I think there's a lot of coordination and discussion. As a potential defendant, I don't know that that gives you a lot of comfort. There's not a lot of, I don't think, transparency into when things may go over, but from a judicial jurisprudence point of view, there's a lot of interaction and coordination.
Are there rules that, I mean, is it completely seamless in terms of any information the SEC collects, and the SEC can share it with the DOJ, or are there rules?
For the most part, they can share information. There might be a few odd instances where you're precluded from sharing information, but I think from the most part, there's a lot of transparency and sharing of information and data.
The information goes only one way, SEC to DOJ, it doesn't go back. Because most of the DOJs are covered by grand jury proceedings, which are secret under Rule 60 of the Federal Rules of Evidence, Federal Rules of Criminal Procedure. So, again, in my experience, I tell people, 9 years at the U.S. Attorney's Office, 3 years at the SEC, I speak both languages and understand them. When I was at the Department of Justice, we made the decisions. When I was at the SEC, the Department of Justice made the decisions. They're clearly, it's the big dog wagging the tail. And almost every case that has a criminal and an SEC component, if they're filed contemporaneously, as they frequently are, the Department of Justice almost immediately moves to stay the SEC case, and the DOJ case proceeds before the SEC. That doesn't always happen, but I never saw a circumstance over the years when I was at the SEC where we did not follow whatever the DOJ's request was.
I think part of it, frankly, is human nature and maybe a little bit of staking out turf, but I think the bigger part of it is resources, right? Each agency is limited by the number of resources they have to do these investigations. And so, it kind of doesn't necessarily make sense for the SEC and the Department of Justice to be doing two big investigations at the same time. So if the Department of Justice wants to take it over, in my mind, it doesn't make sense from a resource perspective for the SEC to continue their investigation. So I think there is a little bit of the human nature, like I've got this, no, I've got this, but I think more it's about being effective and efficient and using your resources wisely.
Oh, we have another question there.
We got two more.
Okay.
Do we need a microphone?
That's fine. Just in terms of, throughout the conference so far, we've spoken a lot about regulators, and regulators seem to always have the incentives to do the right thing. But speaking of human nature, it seems like they have their own incentives as well. So in terms of, again, coming back to fraud proxies, SEC enforcement, the cases that they pick or pick to go after, and the strength with which you go after them also is subject to your own incentives, right? So can you speak to that a little bit in terms of how that affects research inferences, how that affects, any insight basically? I recognize
So to repeat the question, you're looking for some information about how, or the perspective of the panel on how the incentives of the regulator might affect your research and your interpretation of that.
Yeah, because it's just that regulators' incentives are likely to be completely, they're likely to have some of their own incentives, which might not.
Well, I could start the conversation here. I don't know where Shiva is, but I think Shiva has a paper that talks about sort of the incentives of enforcement in bringing big cases and making a reputation from from big, important cases, so there is that part of the incentive. But I don't know if you recall, it was as part of one of the first COSO studies of AAERs, and so this was back in the late 1990s, early 2000. And that COSO AAER study talked about, well, you know, a lot of these AAERs are against smaller companies, and here you can think about what Cindy's talking about is resources. A smaller case, you can do more of them. If numbers count, you know, in terms of number of enforcement actions, you're going to get more if you do smaller cases. So the COSO study came out and said, you know, you're picking on the little guys, essentially. And gosh, you know, maybe that's disproportionate. And so then it was like, whoa, well, you know, we kind of rather have big cases anyway because your reputation is, you know, for reputation arguments. And so then there was some suggestion that moved to more bigger cases. Well, where this is going is that Sue Schultz and I have a paper in CAR that looks at the intersection of, it's actually about restatements and litigation and SEC enforcement. And one of the things we found, and this is one of the problems with litigation as a deterrence mechanism and the class action setting, is that plaintiffs' attorneys are less likely to sue companies over fraudulent financial reporting or financial reporting if you're a small company, stock price is low so the market cap isn't high, so you don't have the investor losses, you know, driving damages. So we have a number of characteristics that were around small companies that looked like litigation would be less likely of a deterrent in terms of class action litigation in that setting. So we suggested that maybe the SEC enforcement shouldn't care so much about sort of this, you're picking on the small guy, because maybe regulation there is going to have important that it play more of a deterrence role because private litigation, civil, you know, private securities actions aren't going to step in. So I'm just suggesting that there's questions here that are important research questions that, you know, we've already got your, I haven't answered your question, but I've said it can generate a number of interesting research questions as a result of it.
And I asked Elaine to jump ahead to slide that's up there now, slide 10, because this picks up from where that COSO study left off and looked at maybe the next decade. And so you can see that there were 87 instances where the SEC leveled sanctions. This is against an auditor during that time frame, and 35. So a little less than half were against a national firm. So about half and half between small firms and large national firms.
So she's talking about the small audit firm versus the small issuer, essentially.
Yes.
So both are part of the same kind of question here.
Trend.
I think there was another question. Yeah.
Yeah, it's not really a question, it's more of a comment, and I don't mean to sound cynical because in fact I think government regulators are always very purely motivated, but I thought that was a very interesting question, and I thought it might be really helpful to have some data on the incidence of SEC lawyers going into private practice and what the relationship of that and the cases they prosecuted was.
I think there is research on that. Shiva, I know, Shiva, you have, yours is on auditors, but does it include lawyers too? It's lawyers. I couldn't remember. It's lawyers. Okay. So there is, yeah, Shiva's study. So.
And another question, I think, Paul?
So I had a question, this may be a really naive question, but how is the decision made as to whether to go after the individual perpetrator of a crime versus, let's say, the company that employs that person?
I've always said that companies don't commit fraud, people do. So it's always been astounding to me that a lot of the prosecutions, I know we hear you can manipulate statistics any way you want, but a lot of times the individuals who are responsible are not punished, or they're punished in a way that's not very significant, and the companies are. It's a lot easier to get a lawyer for a company to agree to a settlement than a lawyer for an individual. So that sometimes drives it. And from again, I think that there are a lot of cases where there are individuals named, but I think that you'd find that the breadth of conduct that's not sanctioned is enormous. And one of the reasons for that is clearly that these things can be hard to prove. But no company I've ever seen, and again, anyone is welcome to disagree with me, no company I've ever seen that's involved in systematic fraud doesn't really have systematic fraud from the top to the bottom. You just can't do it. And I've never seen a case where there's systematic fraud and the senior people did not know about what's going on. And for various reasons, again, it's easier to sanction the company, have the individuals fired. A lot of times that does happen, so there are consequences. But a lot of times the individual prosecutions don't occur because it is difficult. I use the phrase, and I use it with my wife and lots of my friends when they say, well, why didn't something happen? I said, let me tell you what happened, and then let me tell you what I can prove. Two very different things.
So following up on that, it seems that that creates an incentive for companies to not want to come forward and reveal or report incidents to regulators because they bear the costs, not really the perpetrators.
Yeah, I don't know how much that's to a point that Mr. Woodcock made this morning. I really agree with, and I think it is going to be one of the most significant things that have an effect on enforcement proceedings, litigation involving false financial statements is the whistleblower. Because what's happened now is there's actually a financial incentive, in addition to whatever moral imperative there is, for individuals not to sit idly by while fraud is going on. And anyone who knows this, correct me, but at least when I last looked at the whistleblower rules, even perpetrators of the fraud can be whistleblowers. So what's happened now, and I do think it can be a game changer, again, human nature is such that it doesn't always change, but anyone who's involved in fraud can never sleep soundly at night anyway, but they certainly can't sleep soundly at night knowing that other people know about it. And no fraud is ever perpetrated by one person. It has to be perpetrated by multiple people. And any one of those individuals could bring the whole fraud down.
Yeah, I think that would be an interesting research topic. I don't know how easy it would be to do the research on that, but, and forgive me, David, if you talked about this earlier, but, the SEC does have a cooperation program where companies can get credit for coming in and self-reporting and working with the SEC. And it would be interesting to see if there's any kind of research that could be developed around, the types of credit that a company might get for cooperating with the SEC under their program. Do they get lesser sanctions than if the SEC uncovers the fraudulent behavior?
Yes.
I continue to be puzzled why there's as much. I continue to be puzzled why there's as much criminalization of misconduct. I'm wondering what the constituency for that is. That is, certainly the business community can't be particularly enthusiastic about it. The lawyers, I think in general, would prefer to just have private enforcement, if one considers them as an interest group. Not even clear what the extra benefits of criminal enforcement are, but in particular, I'm just not clear who is rooting for it. I don't have the sense that the public at large thinks that it's crucial to have criminal enforcement, especially at the much greater rate at which it occurs in the United States as opposed to, say, Europe. Any speculation about why that would be the case?
I would just say, I think if you lost your retirement savings in a fraud scheme, you might want those perpetrators to go to jail.
Yeah, I think they're, again, I have no expertise on this, it's an important question, but if you listen to some investor representatives, including out of the financial crisis, there's an objection sort of from an equity standpoint and fairness of society that, Wall Street Journal, I think, is keeping track of who goes to jail and did a cover feature on it, if I'm not mistaken. So there is this notion in the wider investor community that you should have bodies on the slab, essentially, if there were major frauds where people lost their investment and life savings.
Yeah, I think it actually goes the other way. There's actually a lack of criminalization. There's a lack of criminal responsibility. If you look at the statistics from the financial crisis, I don't know what the number was, but it was in the trillions. And the number of people who have been held responsible for that in a criminal sense is minuscule.
And Trevor has a question here.
So if I could shift a little bit to Russell and Cindy put up the question or the top of your pillar with the board. the audit committee. Having served on a few of those, is it truly realistic if you are going there, no matter how much time you're spending, if you're not there full time and part of the system, that you can detect fraud and that you can be expected to deliver on so many of the things that we seem to be asking board members to be able to do these days?
You know, I think it's a fair question, and I think that's why you don't see in some of these cases that we're talking about the boards being named as a defendant or individual board members, because they are only there as an oversight role. They can ask the right questions, but they're not responsible for the tone at the top. They're responsible for asking questions about management's tone at the top. And so, as I think Russell was indicating, some of these major frauds that involve the entire management team or large portions of the management team. So I think it is very hard for a board necessarily to know. There have been a few cases where the board clearly was aware and turned a blind eye and were then prosecuted or at least had enforcement actions brought against them. But it's a good question and it's hard. And so that's why they're and what is the saying, noses in, hands out.
Just a comment. I thought that the Department of Justice really got involved when...
He said, I thought the Justice Department got involved.
The Department of Justice got involved in criminal prosecution when the firm had done some sort of initial or seasoned security offering. Is that not descriptive?
Yeah, I'm not sure I understand the question. Try that again.
So, criminal prosecution by the Department of Justice would only come in cases of initial public offerings, let's say, or seasoned offerings. Is that not the case?
No, it's more broadly, and again, it really goes down to how prominent the fraud is and how much money is. I mean, I can tell you, frankly, when I was at the U.S. Attorney's Office, there was a threshold. I mean, if you came in at I'll make up the number, $500,000 worth of fraud, I wasn't interested. If you make millions, okay, then I might be interested. It's very much that way. And to the point I think Cindy made, which is there is a resource issue that just absolutely is there. As much as there's a lot of lawyering, a lot of money, a lot of enforcement, it's dwarfed by the resources of the bad guys and the magnitude of the potential fraud. I mean, to do a good fraud investigation, I know maybe Cindy knows these people. I knew the people who did the Enron investigation at the SEC, and there was a team of people who worked literally around the clock for a long time trying to uncover that fraud. It was massive. I know that was a special case, but it takes a lot. It takes a lot to actually bring these cases. And then again, as I say, once you've uncovered the fraud, then you have to explain the fraud, and then you have to prove the fraud.
And I'd note that, we probably have more that we could talk about on proxies, and I would encourage people to talk to the panel, this evening, or get in touch with them to talk about that topic.
Can I just do 2 more minutes on proxies? Okay. I just want to make sure, because for those of you who do research, just remind that objective evidence is important. For example, restatements for non-GAAP reporting are not fraud unless there's some other objective evidence of fraud. Filing a securities class action is not fraud unless there's some other objective evidence. Regulatory investigations are not fraud unless there's some other objective evidence. And we've had great discussion about predictive models, but as was recognized, those don't give you a fraud sample unless they're supported by objective evidence.
Right, and I think the discussion was naturally leading to what we have as our next topic, the frequency of fraudulent financial reporting in litigation and enforcement and regulatory action. And again, we can point to this morning when David mentioned that there was a survey, and when asked, is there as much fraud today as there's been in the past, every single person said absolutely yes. So that's a good lead into a question that I'd like the panel here to address. What is it that you all think is the frequency of fraudulent reporting? But I'll add a little twist. Because much of what we're talking about and what the proxies led us to is that some of these measures of what we're thinking is real fraudulent financial reporting and the perception of it and the research of it is based on litigation regulatory actions. So is there a gap? You know, how much fraud's actually occurring and how much of it is truly being picked up, type 1, type 2 errors in the types of actions that we're talking about here?
So I'm going to start us off, but I thought it was pretty interesting. I can't remember who said it sometime today, that talked about the frequency of fraud is about 2% across domains, essentially. So I'm going to give you some objective evidence, since that's what I'm pushing today, of fraud. And this is based on non-GAAP reporting. So it's taken from a study that Sue Schultz did for the CAQ on restatements. And as part of that, she looked at restatements from 2003 to 2012. And then tried to identify the fraud component of that, again, using the objective criteria that I've been talking about. And she found that about 2% of all restatements involved fraud. So 2% was consistent with what we heard earlier today. The annual average ranged from 5% in 2003 to 1% in 2012. And then if you remember, all restatements include those that are what we call big R's as well as little r's. And so the big R restatements are those that are the non-reliance restatements that have a filing of a 4012. So those are the big R's. So if you look at big R restatements with fraud, that's a little higher percent, which is 3%. Now, she used the audit analytics variable, and this is a pretty good one. They take it from filings as to whether it was identified as fraud or an irregularity or criminal proceedings, actually, in a filing. And then she added SEC AAERs to it. So the AAER addition gave her about an additional 1%. And again, this is based on objective evidence, and certainly we recognize that some instances of fraudulent financial reporting are not going to be publicly disclosed, but it does look like the fraud rates are low, essentially, that they're, even though they're understated potentially, it's a tail of a distribution of non-GAAP reporting. Now, it's a really important tail. It deserves the kind of attention that we're getting today in other settings, but it is a tail of a distribution.
Russell, Cindy?
I think Zoe-Vonna said it well.
Yeah, nothing to add.
I thought Russell was going to disagree with me and talk about fraud is everywhere.
I'm not smart enough to disagree with you.
No,
So is the message that there really isn't that much fraud, despite what David
No, well, I think part of the problem is that while I think fraud might be relatively rare when you look at the number of public companies out there, if you're talking about financial reporting fraud, the impacts are large. Mm-hmm. And so, it harms investor confidence in our marketplace. The individuals who have a direct, impact because of their investments or their retirement, that's some of these dollars are really big amounts. And so I think it's the erosion of trust and confidence in the marketplace, which is really hard to get your arms around. So while there might be relatively few cases, when you look at the number of public companies who file financial statements every year, the impact is very large.
And we also know from research, for example, that it increases the likelihood of litigation and for auditors, and that larger resolutions for these kinds of cases in litigation.
And at the end of the day, whether the company settles or is prosecuted to the end, who ultimately pays those penalties are again the shareholders and the investors, so they're doubly harmed. So I think it's more the impact than it has than the sheer number.
Yeah, I can't answer the question David asked this morning about, how do I know there's more fraud? All I can tell you is the amount of fraud that I hear about that I know the government's not investigating is substantial. And if you look at some of the cases, again, going back more historically, and I know that they're famous, but the WorldCom fraud and the Enron fraud are just astounding. The number of important agencies, auditors, publics that were involved in that, and yet they were able to commit this massive fraud in broad daylight. It's just astounding. And the amount, I know because I consult with people, and they tell me about the things they do, and they say, well, to the point someone made, should I self-report this? I said, I wouldn't do it if I were you, because the chances of you being found are much less than, well, not as infrequently as being hit by lightning, but there's an element to that. As I think one of the panelists said earlier, 50% of the frauds are uncovered through happenstance and tips.
Which is why the whistleblower program is so important, I think. The only other thing I would say is I think there probably is more fraud just because, and again, I don't have any empirical data for this, but you know, we're still recovering from the financial crisis, and I do think there's probably more fraud committed when people find themselves in dire circumstances. It gets to the fraud triangle, right? There's more justification and there's more opportunity. Companies have cut back on their compliance personnel and their internal resources, so there's more opportunity. So I do think when times are bad, you're probably going to see more fraud, but again, I don't have any empirical evidence of that.
The question?
Yeah, so we've heard 2 or 3 times now today about how important the whistleblower rules are in uncovering fraud, and this question may just highlight my ignorance about the audit payment scheme, but I was curious whether auditors have any incentive to uncover and report fraud, and if not, whether it might make sense to think about instituting some incentives for them to do that.
Yeah, they do have a responsibility to, if they see fraud, to say something. Now, they're not there necessarily looking for fraud. They're looking to make sure that the financial statements are presented accurately. And so it's related responsibility, but not a direct responsibility. But I'm going to get the the law right. I mean, the law potentially incorrectly. So I don't think accountants or auditors are eligible to participate in the whistleblower program because they have a responsibility already to be doing that. So you don't want them to be.
They can participate if they have reported if they've reported up to the partner, or if they're an internal auditor or compliant professional who's reported a fraud internally, and 120 days goes by and nothing's been done, then they become eligible. But
Okay.
as a general matter, they're not eligible.
Did you hear that?
Yeah.
All right. Well, if there's no more on the frequency here, we can move on to some of the common, and we had already covered that slide. So some of the common fraud schemes that we've seen in the past. So Zoe-Vonna, I know that you have been involved in a fraud taxonomy and researched this yourself. So if you could lead us off here, that would be terrific.
Sure. Let me just start off by talking about a study that I did with Sarah Bonner and Susan Young. It's published in Accounting Review in 1998. And as part of that study, we developed a fraud taxonomy. Now, I have to give full credit to Sarah Bonner for this because she did the heavy lifting here. I think she read every fraud study and every book on fraud that was available at the time. And what we did is we developed categories of fraud, and I think the slide gives you a flavor for what we have as our categories, and then the next slide gives you just a flavor for the schemes within that category. So there's multiple schemes within each of these categories. So one example is fictitious or overvalued revenues and assets is a category, and within that category, an example of schemes are sales not based on firm orders to buy. And so those would be sales via invoices to phony companies, phony invoices to legitimate companies, or made-up supporting invoices. These were among the schemes listed in that particular category. So what we did is we applied our taxonomy to SEC enforcement actions to provide some evidence of frequencies of various types of fraud. And the slide here gives you some percentages here of the SEC enforcement actions that in our sample period from those schemes. Now, the taxonomy is just summarized in TAR, but if anybody has any interest, it is published in a monograph on education and training in fraud and forensic accounting as part of the West Virginia University Forensic Science Initiative. It's noted on the slide here. But the essential takeaway here is that even though this study was done 20 years ago, my sense is that the taxonomy stands the test of time, that essentially frauds today are easily classified within the taxonomy like new wine in old bottles, essentially.
And Russell and Cindy, do you agree? Do you see that this might be represented? Maybe this is also a question for this group of researchers, does this stand up to the test of time? What is your sense in the panel?
Well, I think it's a fabulous study, and I think it's dead on. The biblical phrase, there's no new thing under the sun. The amount of fraud you see and the way they do it, and every 10, 20 years you see it sort of replicates itself. You see it again and again and again. You talk to these people and they say, they think they've come up with some new scheme, and you say, oh, no, that was done 10 years ago, and this is how they do it. And the revenue recognition, channel stuffing, and just flat out lying. Those are not new things.
Yes. How are the fraud schemes that are listed in the taxonomy that you've created different from the ACFE's fraud tree?
I can't answer that question specifically for today, but back then, 20 years ago, we used that as one of the sources in developing the taxonomy. So I don't know if it's evolved in any different direction, but it was one of the sources that we used in developing it.
Okay, so we have a few minutes left, and I just wanted to ask the panel in these few minutes that do remain, if you could each identify an issue that consider very important for this group here in conducting their research.
So I'll go first. I already gave you the one that I thought would be interesting, although I have no idea if that's even researchable. But another one that I think is probably easier to get your arms around is, and this is coming from my background in the Center for Audit Quality. We're very interested in the ICFR, the internal controls over financial reporting area. And so it would be interesting, I think, to look in the periods preceding those quarters where the SEC found fraud in the ICFR area to see whether or not the issuers received significant deficiencies in their ICFR opinions. We have not done that work. We did look at the AARs looking at the ICFRs that cited an ICFR problem, but we didn't go to look and see whether or not there was a significant deficiency cited in the opinion. And that would be, I think, an interesting piece of research and probably fairly easy to do.
Before we turn it over to another panel, the CAQ you mentioned, and Zoe-Vonna's on this, you do have some efforts here that people may not know about to promote research. Maybe
We do. The Research Advisory Board of the CAQ, every year we issue grants. We put out a call for papers or a call for people to submit their research ideas, and then we issue grants. And then we also have a new program, relatively new program called Access to Audit Personnel. So if you want to do behavioral research, we can help you through the RAB get access to audit personnel within the firms so that you don't have to go to each of the firms and say, I want to interview 50 seniors. You can put a proposal together and come through the CAQ and the RAB to do that type of research.
And let me just do an added pitch for the RAB since I'm on it. And we're very interested in fraud research. And I recognize that for many people that, a grant of a relatively modest amount isn't going to influence whether you propose or not. But one of the things it does, even if you're not doing behavioral research, is give you access to people in the firms who will help facilitate your research. So it's people to talk to, et cetera, that could be an advantage depending upon your research question and what you're doing.
And then one other point I would make about the grant. So for a more seasoned researcher, academic, as Zoe-Vonna said, it might not be something that's appealing, but we do tend to give a bit of an edge to those of you who come in with a PhD student. So if any of you have students that are interested in doing a research project, they could get the grant, and then you could help advise them.
Or junior faculty too. So
yes, yeah,
we do try to
give
preference to them. So I have two takeaways. One won't surprise you. One, it's to be clear about how you're defining and measuring fraud, and use objective evidence to do so. And also, the second takeaway is I'd really encourage you to immerse yourself in the institutional and legal details here if you want to do work in this area. It's really, I think, important and part of the conversation here to listen to the other panelists and today is to learn how the world works. And so that's, thank you, Peter, for putting on the conference, because I think you're facilitating that understanding of how the world works, and I think that's extraordinarily important in doing work in this area.
And Russell, I'm delighted to let you wrap this all up.
That I think that the thing that I was saying to Peter earlier, the thing that struck me is how many of the panelists agree on some of the basic issues, things like the fact that fraud is not easily uncovered, that fraud is pervasive, that fraud is continuing. I think this provides many great areas for research, and some of the stuff that I'm sure Zoe-Vonna and some of the others of you have done. It's worth, though, every once in a while, and again, I know this goes towards my perspective, is adding a little bit of element of the real world in there. Because many years ago when I was a law student, I wrote a paper for a very good professor at my law school who had been a key department official in the Kennedy administration in the Attorney General's office, and he was very knowledgeable about criminal law. And I had this idea on plea bargaining and how things should be done and all of this, and he said, that's really good academics, but it doesn't work in the real world. Then when I became an assistant U.S. attorney, I found out what he meant. So it's always that element. But I think that there's an intersection where it's both important to understand what the statistics show, understand what the information show, understand what the data show, but then to leaven that with, or to season that with some practical experience. But it's been a delight to work with Peter and my fellow panelists, and thanks for putting it all together for us.
Thank you all.